So, school starts in just a few weeks. Is your court order silent on who has decision making authority over your child's school next year? Or maybe you're thinking about a move that would change everything. Here's the problem: family law courts don't move fast. If you wait until the last minute, your child could start the year in the middle of uncertainty and conflict. Let's talk about why you need to act now. Hi, my name is Carla Hartley. I'm the managing partner for a multi state family and estate law firm, locations in Texas and California. This video is intended to provide helpful information, not necessarily to solicit work on this topic. Actually, we try to avoid last minute filings in every jurisdiction in which we practice. Let's discuss back to school planning and why filing early protects your child's stability. Today, I want to talk about something that comes up every summer in family law cases involving divorce, post divorce modifications, or parentage proceedings: back to school issues. As we head into a new school year, many parents are going to discover that their current court orders leave important questions unanswered. The reality is this: if you have an unclear order, or if you're even thinking about a change that affects where your child lives or goes to school, you need to get the right documents filed with the court sooner rather than later. Family law courts in busy jurisdictions often have crowded calendars, and it can take weeks or even a couple of months to get a hearing and a decision. Waiting until August is simply too late to ensure you get answers or orders from the court before school starts. Let me walk you through 4 common issues we see every year and why early action can really help. First, educational decision making authority. Does your order clearly state who has the final say on school enrollment, public versus private, or switching districts? When parents share decision making but can't agree, or when the court order is silent, conflict can erupt right at enrollment deadlines. Clarifying or modifying decision making authority through the court takes time, and you want those decisions far enough before the first day of school to ensure you can get your child enrolled, especially if you're trying for a magnet, charter, or private school placement. Second, any contemplated change in residence can impact your current orders. Even a move within the same general area can mean a new school or a disrupted routine. If you're considering a relocation that would affect where your child lives or attends school, most orders require proper notice or court approval when the change is significant. These requests need supporting information and often will go to a hearing. Starting the process now gives everyone, including the court, the opportunity to focus on what truly serves your child's best interests instead of rushing into the school year and presenting the court with an emergency that was completely foreseeable and preventable by early action. Third, the practical logistics and costs. Who is responsible for getting your child to school on time during each parent's time with the child? Who covers school supplies, uniforms, activity fees, transportation? If tuition is at issue, who covers tuition? When these details aren't clearly addressed in the order or in an outside written agreement, small disagreements can quickly become sources of stress that spill over into the child's first weeks of class. Updating or enforcing these provisions through a properly filed request prevents last minute battles. Caveat: if you can reach an agreement in time to avoid a last minute filing decision, that's good. Try to reach the agreement even if you've already filed, because if you delay filing and don't have an agreement, you've tossed yourself into chaos. If you don't delay filing, you can reach an agreement and avoid the court appearance and avoid all the chaos. Fourth, access to school information and involvement can be an issue. Both parents generally have the right to report cards, teacher conferences, school portals, and emergency notifications. But sometimes older orders need updating to reflect current technology or to ensure that neither parent is unintentionally left out of their child's education. Addressing this early keeps both households informed and reduces friction. Here's the key point I want every parent to hear: Family law courts move at their own pace. Whether you need to clarify decision making authority, address a residence change, or update practical provisions, the sooner you file the appropriate documents and get your matter on calendar, the better position you and your child are in to start the school year with a clear plan instead of uncertainty. Whether your order is unclear, you're considering a move, or you simply want peace of mind before the bell rings, reach out to an attorney now, even if you don't call us. We only operate in California and Texas. If any of these issues seem to apply to you, call a competent family law attorney who can help you review your current orders, identify gaps, and take timely strategic steps to protect your children's stability. Any competent, experienced family law attorney can tell you how much smoother the school year goes when these issues are handled proactively. A short consultation can give you a clear roadmap and help you file well ahead of the commencement of the school year. Again, my name is Carla Hartley. Thanks for watching. If this information was helpful, please like, share, and subscribe so other parents can find it too. I wish a calm, organized start to the new school year for your family and every family listening to this.